members of Parliament. I understand that the MDC is also challenging some of those cases in the court. What can you tell us about that?
Yes. Let me start with the members of Parliament challenges. There are 21 challenges that have been filed by the MDC on various grounds challenging the parliamentary election. But we have about 4 that were challenged, that were filed by ZANU-PF. So all in all, we are dealing with about 25 election challenges. One has been completed, and this is Chegutu West, where at the command center, the constituency command center, our candidate won. But when the results were announced at the ZEC command center at Sheraton, the results were switched. We brought this to the attention of the Zimbabwe Election Commission, who acknowledged the error. But they then said that they had already declared and they could not undeclare the person that they had declared. And that we should go to the Constitutional Court, to the Electoral Court. We have taken this matter to the Electoral Court. To our surprise, even the Zimbabwe Election Commission contested in the Electoral Court. We are awaiting judgment. The other matters are awaiting set down. We have an interesting challenge by ZANU-PF in Chipinge East. The ZANU-PF candidate surname is Mlambo. The MDC candidate surname is Mlambo as well. And the ZANU-PF candidate gravamen with ZEC, it's a grievance with ZEC, is that ZEC refused the use of his nickname on the ballot paper. He said the nickname is the one that he was known, well known by, and he wants the Zimbabwe Election Commission, he wanted them to put his nickname. That again is coming. So we think that the election petitions will be completed in the next month. The presidential petition was decided by the Constitutional Court. As you know, the Constitutional Court is the highest court of the land, and its decision is final. So as far as court challenge is concerned, that is the end of story. We cannot have another court challenge on the presidential election. The lawyers for the alliance have advised approach to the African Commission, and that approach that appeal has been laid to the African Commission. The African Commission will have to adopt a 2-tier approach. First, whether it can hear the case, and then if it decides that it can hear the case, then it will proceed to hear the case on the merits, and this usually takes very, very long. But the decision of the Constitutional Court does not dispose of the matter in real fact. It disposes of the legal challenge. It does not dispose of the endemic problem in the Zimbabwean society. We have a society divided basically into 2. We have presidential candidates who scored almost 50-50. So we have a divided body politic. And no court judgment can resolve that. And therefore, there are other methods that have to be undertaken to deal with the Zimbabwean crisis. The political methods that can be undertaken. Number 1, mass protest in terms of Section 59 of the Constitution is on the cards. Number 2 is the issue of dialogue. But this dialogue has to be on clearly defined parameters. So yesterday, the National Council of the MDC met and recommended the multi-pronged approach to the Zimbabwean crisis. So the crisis is far from over, it is still there. And the court case sadly has not disposed of it.
How do you respond to people who say you could have avoided all this, especially the election petitions, if you had even asked for a recount or an independent audit of the ZEC results? So why didn't you?
Yes, we have had that criticism, and that was the major criticism by the Constitutional Court judges. But in the case of Timber versus the MDC, that is the 2013 case, we requested the reopening of the ballot papers, of the ballot boxes, and the same court flatly denied, refused the opening of the ballot boxes. And the reasoning by Justice Bono was that this is a harmonized election, and if you want to ask for the opening of the residue, you are going to affect people who are not part to the court proceedings, the members of parliament, the councillors, and so on. It was a strange reasoning to us, with due respect to Justice Bono, but it was reasoning nevertheless. So the court has made pronouncement about the reopening of the residue in the past. And their position was that it is a no-go area, you don't reopen. So we thought that the court was going to be consistent with its reasoning, and therefore we decided to challenge on the available material that we had. And you may also know that we sought to introduce key evidence via some of the respondents, Dr. Manyika and Mr. Mangoma, and the court rejected that evidence. And that if we think that if that evidence had been admitted, it would have been enough. We also think that purely on the figures given by ZEC, the three figures that were given by ZEC, the election should have been vitiated. But sadly, the Constitutional Court was not with us in that reasoning. So yes, criticism, we accept that criticism, but the explanation is the historic approach by this same Constitutional Court. We did not think for a minute that it was going to reason differently from the way it reasoned in 2013.
But you still went to the same court that you didn't think was going to give you a favorable response. So wasn't that just a waste of time?
We are not going to surrender the Constitutional Court to anyone on the basis that it has been unfair in the past. It is an institution that is supposed to be fair. People do change their attitudes over time. People do see the light. There's always what is called the Damascus moment. Just in case this Constitutional Court had reached its Damascus moment, after all, there were signs that people were going to be fair. But if the Constitutional Court was of the later wisdom that you needed to open the material, it was not known to us. Previously, it has said that is a no-go area, and we had relied on that precedent.
And you said, just last question on you, Mr. Mwonzora, that more protests are on the cards. Isn't that a bit dangerous to say right now, given what happened on the 1st of August, where some of your supporters were killed? And how do you respond to people who then say, is it not time for some more thoughtful and considered plan to emerge from the NDC rather than the continued activism and reaction that we get, after, to the ruling party? How can you respond to this?
In 2013, over 95% of the people who voted in the referendum voted for the Constitution. And one of the attractions of this new Constitution is the Bill of Rights. And I can say almost with certainty that the Constitution that we have provides one of the most comprehensive Bill of Rights on the African continent. And to surrender any one of those rights is to retrogress. One of the rights that are in the Constitution is the right to peacefully demonstrate and present petition. The fact that the state has reacted unreasonably, reacted harshly, is no good reason to surrender that right. We are demonstrating in the context of the Constitution. It is a lawful option. So we are exercising our rights in terms of the law. The fact that we have a regime that is bloodthirsty, we have a regime that overreacts, is neither here nor there. So we are going to embark on peaceful demonstrations. Yes, we will, of course, look at other methods of making the demonstrations more effective. The cowardly acts by the army, and if you go to the pictures of that soldier, I think he wanted to impress a girlfriend or something. The way he was shooting indiscriminately into the crowd, the pause and everything, so sadistic, so evil. So if we are to succumb to that, it is tantamount to succumbing, it is akin to succumbing to terrorism. That is why countries like the United States, Britain, have a standing policy that they do not negotiate with the terrorists. So we are not going to surrender to terrorism. We are not going to surrender to these terrorists.